My name's Rod Genders from Genders and Partners Solicitors, the oldest law firm in South Australia. And today I'm introducing a free ebook that we've created entitled 7 Things You Must Know About Deceased Estates in South Australia. Now this is just a brief introduction book, but very helpful, particularly if you're just beginning your journey of discovery. Perhaps you've recently lost somebody close to you and you've been tasked with having to administer their deceased estate. This little book will definitely assist you. So in the book we talk about what is probate. There's actually several different types and flavours of probate. The one that most people are interested in and have heard about is called an application for grant of probate in common form, which is the simple administrative form of probate. But there are others, including if you don't have a will, or if you do have a will but no valid appointment of executor, and there are differences in dealing with all of those different approaches. We also talk in the book about the basic duties of executor. I can tell you very quickly, the first duty of the executor is to satisfy yourself that the piece of paper that you think is the last will and testament is in fact the last will and testament, because you've got to lodge that at court. That goes up to the probate court and stays up there forever as a matter of public record, so you don't get the original will back. And another duty of the executor is to publicly disclose all of the assets and liabilities of the deceased person, valued as at the day they died. And that is regardless of whether the asset holders, like the bank or whatever, actually need probate for that particular asset. If any asset in the estate requires probate, then you have to get probate. But in the process of applying for probate, you must disclose all assets. And if you don't, you can get into big trouble. South Australia is one of the few places in the world that maintains both civil and criminal penalties for an executor who fails or refuses to disclose publicly the assets and liabilities of a deceased estate. Who should serve as executor? That's briefly discussed, and quite interesting information. We talk about how executors can be paid and whether they're entitled to charge a commission. And we talk about legal fees and expenses. Most people would be aware that the government charges a court application fee, and that is, in South Australia, dependent upon the amount of the assets valued in the estate. So it's a sliding scale. The government fee is determined by the value of the assets in the estate. We talk about how property, both real estate and other property, can be dealt with and how it can be sold, why you need a grant of probate in order to deal with real estate, but the timing of it can be worked out so that in certain circumstances you can actually list real estate for sale and enter into a contract for its sale prior to probate. But there's a trick to how do you deal with that. We talk about challenges to a will and also challenges to an estate. Many people confuse these two different things. They all talk about challenges to a will, when in fact challenges to a will are more rare. These relate to things such as people feel that the will might be fraudulent, or that it wasn't properly executed, or that the testator, that's the will maker, perhaps lacked capacity, or was in poor health, or was under undue influence when they created the will. Those are certainly possible challenges, but they're far rarer than challenges to the estate, which is where the will is quite valid, but somebody wishes to apply to the court under state legislation, seeking greater provision than that which was left to them in the will. Very different types of claims and challenges, different timeframes, different fees and expenses involved, and we talk about those briefly in the book. So it's a short introduction to a comparatively brief book. We are the oldest law firm in South Australia, established in 1848. So we have been helping South Australians and their families for over 170 years. And we specialise only in trusts, wills and estates. And we would welcome the opportunity of assisting you and your family.